Well, a case in Ontario has prompted quite a debate in Canada, maybe at the same time exposed some confusion around the issue of self defense and a homeowner who's been charged following an altercation with an intruder. So, joining us to talk more about some of these issues, very pleased to welcome here to the program Peter Sankoff. He's lead counsel with Sankoff Criminal Law, also professor of law at the University of Alberta. Much more at petersankoff.com. Peter, so great to have you with us here.
Happy to be here.
It's tricky with this case in Ontario, and there's a lot that we don't know about this case. I know the CBC had a story this week about the intruder possibly being armed with a crossbow. Maybe there's some suggestion these two might have known each other. How important is it for us to know and to learn as much as we can about this case?
So, I mean, jumping to conclusions is the lifeblood of many people in our today's society and also
Yeah.
of politicians. As lawyers, like we learn early on not to do that because, especially in this area, like there are certain things that are easy to determine and you can jump to whatever conclusions you like. But when you're dealing with something like self-defense, it is one of the most idiosyncratic defenses there is. It so much depends on the facts. And it's really easy to demonstrate that just with some basic examples. Like everything is going to turn on the nature of what you know about the situation. And in this case, we don't know a lot. So I would, number one, just caution people before they jump to conclusions.
Right, and that's the tricky thing. And obviously, the lawyer for the guy who's been accused, he's going to be careful in anything he says. Clearly, the police are very careful and tight-lipped when it comes to protecting their investigation. So it is difficult for people to get the information, even though there is a lot of obvious public interest in a case like this.
That's right. And that's always the case. I mean, even where you have more information, it's really easy to jump to conclusions because you're missing some of the context about what was actually going on in that particular case. I mean, in this case, you can draw certain legitimate inferences from what we know, but the rest is just speculation. Like, for example, from the bits of stuff that we've heard, the most significant part of that today was the idea that they knew each other. And once they knew each other, it changes the context of the encounter dramatically. It does that because now we need to understand what that relationship was. And that doesn't, just to be clear, I'm not saying that the fact they knew each other is definitive, that it was or wasn't self-defense, like none of that. But I'm just saying that it raises more questions about what happened.
Mhm.
And it certainly raises more questions about how the defense would be applied if this actually goes to a full-blown criminal trial.
And I guess that's the issue of self-defense. And I think, people are making note of the fact that the police decided to lay a charge here. And obviously they saw something that crossed the line. But when we look at the defense as it's laid out, I guess it's section 34 of the criminal code.
Mhm.
I mean, does it fall to police to make that determination? Is that something the Crown determines? Or is that meant to be an argument that's presented at trial?
So that's going to be determined on a case by case basis, but I will start by saying this. It is just not true that the police lay charges every time
Right.
there's a self-defense type scenario. Nor is it true that they always lay charges in a scenario where someone dies. I've seen that not result in charges before. And I guess part of the question here is do we trust what the police have done? Is there reason to be concerned that they've gone too far in dealing with this problem? And again, I would just stress some caution because we don't really know the answers to those types of questions. So self-defense is a very broad and ambiguous defense for a reason. It's
Mhm.
for a reason. It is the most difficult defense to factually police because it can arise in so many scenarios. But I want people to understand that the fact that this guy has been charged does not mean he will be convicted. It doesn't even necessarily mean that it will process to trial. Let me just put it this way. There's really only two possibilities here. One is that the police, and if the Crown reviewed it, let me say, Rob, that's different in every jurisdiction. But I kind of feel like it's very likely that a Crown was involved in this. So there's only two possibilities. One is they're just completely covering their ass, for the, colloquial way, and saying, let's just leave that. We'll put it in so that everybody knows it's treated seriously and we're going to deal with it. Like, I think that's a very unlikely inference. And I think the more likely inference is the second possibility, that there's just questions or more. Questions or more. I don't know what it is, but something about the way this went down gives them reason to pause. So to me, there's only one of those two possibilities. One is a mistake, because I don't think they should lay charges without having investigated the matter. And I bet they did investigate the matter, and they at least have some questions about what took place. So all this jumping to conclusions and trying to fictionalize this encounter in a way that makes it outrageous that he was charged, I think is just a falsehood. I don't think that's very likely at all.
Well, and I think where it resonates with people is the idea that if I'm in that kind of a situation, or someone breaks into my home, what should I be worried about, or where are the lines, or what can I do or not do, right? And I mean, ultimately, it doesn't help us, I guess, to look at one individual case. Really, I think maybe it's more about cases, plural, right, that we've seen and where we've had some established precedent, and ultimately what's in the criminal code, right?
Yeah, so I just will say this, like, the defending your home thing already gives you much more leeway than any other situation. And one of the reasons for that is, in any other situation, any other one, the court is going to look at one factor, being, did you take reasonable steps to extricate yourself from this situation in some other way? And like, that is something that we consider in every self-defense case. And let me stress, that's never definitive. But if I'm in an alley with some guy and he's coming at me and I can easily get out of the alley, the court's going to consider that. But in your home, it is still the law now at common law that there's no obligation to retreat. You are in your home.
Right.
And that is good law today. So you already have more protection in your home. But being in your home doesn't end the story. And of course, it can't end the story. And you can do anything, and you can do this, and you can do that. You'll get much more leeway. But if someone breaks into my home and, I shoot them in the leg and they're immobilized, and I decide to shoot them in the head, I'm still going down for murder. Like, it doesn't matter. There's no special home inspection. Like, I've heard stuff like that too. If you're in your home, you can do what you want to defend yourself. No, you really can't. We don't live in that world. We live in a world in which you can use reasonable force to defend yourself. Trust me, that word of what's reasonable force dramatically rises when you're in a life-threatening situation, like someone has broken into your home. So you've already got a lot of leeway. It's already there. And the idea as well that you can respond to the type of force that's coming at you and the situation, you're startled. And people are like, well, what if I shoot him and he dies? Like, I used too much force? No, it doesn't work that way either. Like, these are misconceptions about how the law operates. The result is not what matters. If somebody is coming, trust me, that if someone is coming into my house and I own a firearm, I do not. But if somebody comes into my house, right, and I hear them coming up the stairs and I have no idea what they're doing, I don't have to wait to figure it out. It's not my problem. And if I shoot them, and I shoot to put them down in some way, and they die, I promise you I'm not going to spend a day in jail for that event. But the problem is, we don't know that that's true in every case, because the alternative, what some people or some premiers have been suggesting, is if someone breaks into your house, it's open season, and it's not. It can't be. It's just it doesn't work that way. Because keep in mind that in all these cases, what nobody's remembering is that these cases work for mistakes too, and the courts are very concerned about that, because a lot of these break-ins into your home are mistakes. Now, let me be clear. I don't want to punish mistakes either. If someone is coming into my house and it turns out it's I hate to use any example, it's going to be bad, but let's say it's my cousin who sometimes sleeps in the basement, and they sneak in, they're trying not to disturb me. And I come down with a bat and hit them over the head. I'm telling you, I will probably escape liability for that too. But again, we're very hesitant about saying in your home, all bets are off. You just can't do that. It's not an acceptable way of approaching the criminal law.
Right. And when it comes to Section 34 or anything we put down in writing, like there's no way we can have criteria that can cover every possible scenario. Like inevitably, there is going to be some gray area here, I imagine.
So what's hilarious about all this, to me, this is the great irony that you've hit on, is that like this new Section 34 is a reform that was put in around 2015.
That's
And
right.
it's a little earlier, I think, but I can't remember the date, but it was put in to reform the previous system that tried to do just what you said. And it was an absolute disaster. It had 6 forms of sexual self-defense, and it was incredibly complex. I actually think Section 34, by and large, has been a triumph. It's been one of the best legislative developments we've had in recent times. I really believe that. And trust me, if you listen to anything else I say, I'm not a big fan of the criminal code reforms that have been taking place. But
Mhm.
this one, I give it to them. They simplified it dramatically, and they left it to juries, judges in cases where it's judge alone, to decide based on all the circumstances. It doesn't mean they're always going to get it right. Nobody always gets it right. But it's the more we try to really precisely say what you can and can't do, the more problematic we become. Like it's not a good idea when it gets down to trial time.
I mean, I don't suppose there's any other way around this. I mean, I think of, like, for example, if a police officer uses a firearm in self defense, there's kind of a process, a review process that decides whether it should go anywhere. I don't know if we can have any kind of separate process like that in self defense cases. Is it inevitably going to still fall to police and the Crown to make that determination?
Well, that's a different question. Like, I'm not so sure about that. Like, that is a different question. There are other systems available. Like, I've been debating with another professor from Saskatchewan about this online. And what we've gone back and forth on, like, we used to spend a lot more time doing things like coroner's inquests and fatality inquiries.
Right.
And I've come around to the view that in these borderline cases, and I'm not commenting on whether that one's borderline or not, because I don't know what the investigation is. But I am of the view that in borderline cases, I'm not a fan of putting someone through a criminal trial in this way. Like, if it's clear that it's not self defense or there's a really good arguable case to make on that, by all means. But my basic idea is, and just to be clear, in self defense cases where the person doesn't die, I would run those through the ordinary process as
Sure.
well. But where you have a death, I don't think there's anything wrong with saying this is serious. It's too serious to just leave it to the Crown and the police. And maybe in cases where the Crown and police are not convinced to charge, it goes to something like a fatality inquiry, which ultimately can raise new findings that become problematic for and maybe lead to charges. Like, I think there's something to that. It would take some, work to get these sorts of things set up, but I certainly take my colleague's point that in some cases the death of an individual is a serious thing, whether it's a break-in or not. Like, it's just, there is no one size fits all. It doesn't work that way because life doesn't work that way.
And I mean, the challenge of maybe where there's ultimately some vindication at some point, or at least an acquittal in court, or police drop the charges, there is still that whole process, right, of hiring an attorney, possibly having to get bail and all of that. That there is a lot that goes into that whole process of navigating the criminal justice system.
So I think the criminal justice system is the worst place to be that you can ever imagine. And anyone who wishes it on somebody who hasn't been there themselves is quite a sadistic person, whether they know it or not. Like, it is a terrible place to be. And I am always reluctant to say this must be criminalized or this must happen or that must happen. Like, I am not a fan of that. If the criminal justice system is not the solution to the problem, then it should not be engaged because of what it inflicts. I am very confident of the fact that very few people walk out of the criminal justice system with acquittals and have not had their life radically transformed, unless that happens at a very early stage in the process. So trust me that an acquittal is vindication in one sense, and it's really just the end of punishment in another sense. Trust me, Rob, you don't want to be charged. Neither do I.
I believe it. I believe it. Well, we'll see what comes of all of this. We'll leave it there for now. Professor Sankoff, appreciate the insight and appreciate you making some time for us here.
My pleasure. Thanks for having me.